Welcome back to Made for More. I am your host, Holly J. Moore. Today's episode is just a little bit different. I don't know if you know this, but my day job is as a lawyer. I am a divorce and custody lawyer. We do family law. I have a law firm, More Family Law Group. And every now and again, I just like to riff on some legal stuff. One could say it's my opportunity to get more legal. Today, I want to talk about California child support. I even wrote myself a little outline here because I don't want to get canceled at the top of the show. I have some pretty controversial views around child support and what we should do about it and how it should be done. But before we get to that, I want to just really kind of take you guys through how child support actually works in California. In case you don't know, I'm a California divorce and custody lawyer. I'm a certified family law specialist. Only about a handful of us in California have those letters behind our name. It just means that we practiced for a while, took an extra test, passed like a bar exam on steroids, got signed off by some judges and some other lawyers in the community. Anyways, that part doesn't really matter. All that to say, I know what I'm talking about when I talk about child support. So let's get into it. Okay, so in California, if you have a child with another person, it's likely that child support is going to be an issue in that case, assuming you're no longer romantically linked to that person and you're now in more of a co-parenting relationship. The two biggest factors in child support, yes, child support is a formula. We have software that calculates it for us. It's an algorithm where a bunch of different factors come into play to determine child support. Things like tax filing status and number of exemptions, health insurance, property tax deductions, things like that all come into play. But the two things that matter most and that are most determinative of child support in that formula are each parent's amount of time with the child or children and each parent's income. Now, I see all the time on the interwebs, of course, the place where everything is true and accurate and correct, insert sarcasm there. I see all the time, you don't need a lawyer. These things are done by a formula. Like it's all set for you. It's software. Yes, that's all very true. Not the part that you don't need a lawyer, but the part that it's a formula, 100% true. Where there's a lot of gray area and a lot of wiggle room is the numbers that we're putting into the formula. Those can have like a huge, significant, depending on what you put in, it can determine the outcome in a much different way. Okay, so you're thinking, well, Holly, how could there really be a lot of gray area on the issue of one person's income? I'm so glad you asked. I'll give you a few examples. We'll just take an easy example. Let's say you have a W-2 earner, a person that gets a paycheck, and they don't own a business. There's, nothing like profit distributions or anything like that. So with the most basic of sort of payment schedules or compensation structures, there can be gray area. Because, for example, we look at a paycheck, we see the number for income. It always goes on gross income, by the way. This upsets a lot of people, but it's gross income. So it's before taxes are taken out, deductions are taken out, all that. It's gross income, not what you actually bring home. But let's just say that person also gets a car allowance or maybe a cell phone allowance, or maybe they work a day of overtime here or there. Those can all be sort of teetering factors that get added back in that people maybe aren't aware of, or, when they think it should just be based on their income, what they're bringing home, not so fast. Another sort of gray area is, let's say you have a person working at Starbucks 30 hours a week. Well, are they capable of working 40 hours a week? That would be another example of a gray area, because maybe there's a request that a salary commensurate with 40 hours a week of work gets put into the formula versus the 30 hours they're actually working. Those are super basic, easy examples. It gets a lot more complicated when we get into business owners or executives who have stock options and deferred compensation packages, golden handcuffs, perks through the job, per diem, all that kind of stuff. It can get a lot more complicated. Now you're thinking, okay, well, timeshare with the child. How much time is each parent spending with the child? That should be pretty straightforward, right, Holly? No, there's also gray area in that because a lot of people think, okay, well, we share our kid, equally, 50-50. And, little Johnny is with me 15 days out of the month and with the other parent 15 days out of the month. Well, one, we actually count hours, not days. This, again, trips a lot of people up because they want to just count days. We actually count hours. And when you have school-age children, who gets the hours at school? Another, while the kid is in school and not with either parent, another sort of gray area aspect to this. I actually just learned something new last week. An attorney that works at Moore Family Law Group, my law firm, I heard him say, yeah, we call that the throw-up rule. And I'm like, huh? What? He's like, yeah, if the kid throws up at school, who are they calling to come pick that kid up? That's how we know who to assign those hours to. So I guess you can think of it as the throw-up rule. But in any case, these are not straightforward things. There can be a lot of gray area with what we are inputting into the California child support formula. Okay, all that aside, you're probably thinking, if you're familiar with child support, you're either receiving it or you're paying it. If you're paying it, you're thinking, this is the most unfair thing in the world. And I tend to agree with you. I don't want to get super into that because, again, we'll wait till later in the episode for me to get completely canceled based on my views of child support. But here's what you need to know about child support, because I've had cases where one particularly severe case was, I'm giving you cases that are like extremely unfair. One particularly unfair case was I represented husband or dad, we'll call him dad, because by that time they were divorced. And he was a very high earner. And mom tragically had really severe problems with alcoholism. And so mom had supervised visitation with the kids for literally like 2 hours a week. And dad still had to pay to mom a pretty significant sum of child support because his income was really high and her income was low, even though she only had the kids for a couple hours a week. And even though dad had to pay for that supervisor, dad still had to pay some child support. And again, it's because of the way that formula is set up and those two factors, income and timeshare. Now, you're thinking, well, Holly, that's absolutely asinine. Why would we have that? Because there's also a lot of cases where the parents both great parents, both super involved, sharing the kids absolutely equally, and one parent still has to pay to the other parent a significant sum of child support. And you're thinking, well, why is that? Why could that be? Why should that be? And here's what you need to know is the state has made the legislature this way because their entire purpose is to keep people off of welfare. So basically, the child support laws in California are set up to where they look for any warm body they possibly legitimately can, and they look for as much money as they possibly can in order to get these child support orders so that it's keeping people off of state aid. So when clients are coming to me and saying, this is so unfair, child support is taking most of my income, most of my disposable income, how could this be? Does the kid really even need all that money? I mean, that's the other kicker too. So we represent some pretty high earners, and I've got clients with child support orders of, $50,000 a month. And it's like, what kid needs $50,000 a month to live on? And no kid does, by the way, and there's some remedies for that. I don't want to get too far into that now, but point being is California is a rough state to have to pay child support in. One, because the entire purpose of it is to keep people off of state aid. And because of that, they're looking for anybody to pay it and the most amount to be paid. Okay, so now that you know that's how child support works, can you imagine how much litigation over custody is really financially motivated? I have the, I will call it the honor and the privilege of having a front row seat because I really like helping people in these particularly hard situations. Most people don't see the ins and outs of this. I see the ins and outs of this all day, every day for almost 20 years now, where there's a lot of custody litigation, a lot of parents vying for time that I can't help but think perhaps is financially motivated. I mean, do I want to believe that all the moms out there are vying for every single minute with their child because they believe that's best for their kids? Of course I want to believe that. And there are a lot of cases where I'm sure that is true. But there are also a lot of cases where I can't help but think that maybe some of that litigation is financially motivated because the more time they have with the kid, the more child support they're going to receive. Same thing for dads. Do I want to believe that every dad out there is just vying for every minute with their kid because they think that that's best for the kid? Yes, I want to believe that. And there are certainly cases like that. Of course there are. But I can't help but think there are also cases where they're trying to reduce the amount of child support they pay. And I'm using mom, dad generically and very sort of gender typical. I apologize for that. It's just for sake of discussion because there are some moms that pay child support and some dads that receive it. So don't cancel me on that. You'll have other reasons to cancel me later. Okay, so now that we know this is how child support is set up, now that we know there's a lot of financial motivations to get as much time with your kid as possible that maybe not is completely driven by the best interest of the child, this is what I think. This is what I lay in bed at night awake thinking about, what would happen if we just took child support away altogether? I personally believe in 100% personal responsibility. I believe in creating your own destiny, your own fate. I believe in making your own economy. I believe in all these things. And I also understand that I'm a lawyer. I have a lot of education. I've got letters behind my name. I'm able to make a decent living. And maybe there's some sort of privilege, within that. And people are going to be upset with me for coming at this with this perspective. But here's what I think. I think parents would be so much more likely to work together if there was no child support involved. Okay, because hear me out. So let's just say you're co-parenting with another parent. And now you can't rely on somebody else to pay that child support. You've got to make your own way. And so you have to work. You would, assuming the other parent is safe to be around the kids and looks out for your child's best interest and all of that, and hopefully they do because you had kids with them. Let's just not forget that. You had kids with this person. So they got to have some level of meeting your standard as a human being. I know that there's exceptions to this rule, but just go with me for a second. If you have to go to work, why not just call up dad and say, hey, I'm working these days because I got to pay my own bills. Will you take little Johnny? Will you care for little Johnny? Right now, that doesn't happen very often because everybody's so terrified to give up time because of this child support formula. It would decrease the custody litigation. I would predict it would cut the custody litigation in half. If there were no financial motivations that were truly driven by child support, I think it would decrease the custody litigation in half. And the third reason, I got lots more reasons, but I think I've probably been ranting for too long by now. So I'll just give you the third reason is I think in the kids' eyes, this would be so much better because it would take out all these sort of underlying, sometimes implicit, but also sometimes very explicit, well, your dad hasn't given me child support for that. Well, your dad is paying for this and that, but not paying for you. There's a lot of that goes on. Well, your mom is spending the child support that I'm giving her on getting her nails done. Or your mom is spending the child support I'm giving her on shopping. All of that goes on all the time. I hear about it every day. So I think if we took child support away completely, both parents would be so much more motivated to truly do what is in the child's best interest in terms of time with the children. They would feel empowered all on their own to sort of make their own way and have to make ends meet all on their own. And it would be a level playing field for the kids. And you would take all of those sort of undercurrent of this sort of weird money issue as it relates to the kids. It would take that out completely. So I'm interested to know what you guys think. Do you think this is the most asinine, horrific thing you've ever heard? Or do you think I'm onto something? A prenuptial agreement, or sometimes called a premarital agreement, is an agreement that two parties enter into before they get married that basically chooses to deviate from state law. It assigns rights and responsibilities regarding assets and debts that are acquired during the marriage. Some common misconceptions about prenups are, one, that they basically doom the marriage to failure, or that it's really planning to divorce, and neither of those things are true. But the real value of a prenup is talking about and creating rules around how the things that you acquire during the marriage are going to be characterized. A prenup can protect things like art collections, real estate portfolios, businesses, all those types of assets. The ideal timeline to get a prenup is not 2 weeks before the wedding. The final version of a prenup has to be presented to the parties 7 days before they actually sign it. So there's like a 7-day waiting period. As soon as you get engaged, you should seek a lawyer's advice and counsel on a prenup and start the process then, because the closer the prenup is signed to the wedding, the more likely that the court is going to think there was some sort of duress involved in that person signing it, and they have to prove that the prenup was signed voluntarily in order for them to be enforced. At Moore Family Law Group, we represent a lot of high-profile people, celebrities, professional athletes, business tycoons. If you already have a lot of assets, or you think you're going to be acquiring a lot of assets during your marriage, we are the best ones to protect that for you and help you make your marriage stronger. Call Moore Family Law Group today.